Okay, so selecting new clients, selecting new cases, some tips I think will be helpful for you, especially when you're starting out, and especially if you're on your own. The tendency is to want to accept everything that comes in the door, but there's a real skill set that you need to develop in deciding, are you going to take this client, or are you going to take this case? The most important thing you got to remember is, in most cases, once you take the case, you sign the retainer agreement, it's maybe not so easy to get out. And you may be getting yourself into something that you really hadn't anticipated. So some careful thought before you say yes to the client is something you need to develop a skill set for. So first, let's talk about the interview. You have a brand new client comes into your office, and you're interviewing them about their case. Now, the first thing you have to understand is that clients don't understand what is and what is not important in terms of the legal issues involved in your case. So it's very important that you really probe with questions. Don't just let the client talk and tell you, because they may leave out very important facts. To them, it's not important, but it could be a game changer in your case. So you need to really spend a time with the client, probing, asking the questions. You need to give some thought to what questions you're going to ask the client before the interview starts, based upon what you know about the case. The second thing is, you need to take copious notes of that interview. Don't think, yeah, I'll remember. You're not going to remember, especially if you're busy. So you either need to take copious notes. You could record the interview if the client feels comfortable with that, or if that's not available, have your assistant come in and take notes as you're speaking with your client to build a good record for your file. And what I like to do, I think it's a good practice, is even after the client walks out the door, dictate a memo to the file based on those notes. You're going to pick that file up 3 or 4 months later. You're going to think, what was this case about? You try to remember. It's going to be really nice to have that memo in your file while all the facts were fresh in your mind, to be able to go back and review it. Rule number 2, talk once, listen twice. Lawyers love to hear themselves talk, but the interview is for time for you to listen. Yes, you're asking probing questions, that's true, but listen to what the client is telling you. Don't be so enthralled in telling the client what you're going to do. Listen to them. Rule number 3, do not accept everything that walks in the door. Now, I know how that is when you're first starting out, especially if you're on your own. You need income. You need new cases. You're excited and enthusiastic about jumping in and practicing law. But everything that walks in the door is not acceptable for your practice for really 3 reasons. Number 1, you value the case. You value it legally. Is this meritorious? If you accept a case that everybody can tell is completely without merit, you are making irreparable damage to your reputation in the community. You can't do that. And what's really difficult is a client comes in with a case that has no merit, but they have money and they're willing to pay you. And that temptation is to take that case. But if it's frivolous, if it has no merit, I don't care what you say, you're going to reflect badly in the community, your colleagues, opposing counsel, the court, that everybody knows, and you must know that this case has no merit whatsoever. The second thing you need to talk about in terms of valuing the case is your competence. Now, the problem with the legal profession is, except for patent and trademark law and a couple other areas, you get that license, you can practice in any area that you want to. But the professional rules of responsibility require you to be competent. So if somebody comes into your office, especially when you're new, and they have some area, it seems interesting, but you have no experience or competence in that area, and you take that case, you are asking for trouble. It could end up with an ethical grievance. You could end up losing the case. There could be malpractice. If it's outside your area of competence, the best thing you can tell your client is, I think you have some value here, but this is not really within my area of practice. I'm going to refer you to so-and-so. And then the last thing you value is the economics of the case. Sometimes you have cases that have a lot of emotional draw. In other words, a real wrong has been done, and you know you could do something about that. You could right that wrong. You could help that client. That's great. That's something you should consider. But the second thing you have to ask yourself is, can I get paid? And it's hard to say no sometimes, but especially when you're first starting out, you can't afford to have your caseload full of cases that aren't producing any income. Now, after 20, 30 years at practice and you want to start taking pro bono work and doing something, that's fine. But in the beginning, that question always has to be answered. Can I get paid here? And if you can't, maybe you have to say no. And that's the last thing I would say about this is you have to know how to say no. It's very tempting sometimes if the case has some appeal to it from the merits, or the client has money, or there's some other reason that you would really like to take it, but you're hearing that voice in the back of your head saying to you, you can't do this. It's hard to say no, but sometimes you have to, and you'll find during the course of your practice that your ability to say no will add great value to your practice. So I hope this was helpful for you.